Well, good afternoon and welcome to the third session of Business Succession Planning, put on by Water Systems Council, directed at the water well industry. And today we're going to be talking about a popular topic, especially these days, I think, estate planning. And maybe popular is not the right word for it, but I think a lot of people are beginning to think about the necessity of doing estate planning. And estate planning is not the entirety of business succession planning, but it's an important part of it. So if we go to the next slide, you'll see that today we're going to talk about um, we're going to talk about advanced medical directives. In some states, that's called a living will, or it might have another name. We're going to talk about wills, of course, and we're going to talk about powers of attorney. We're going to talk about trust, which may not be for everybody, but it's something that we need to be aware of. In the past, tax issues have really dominated estate planning, and the good news today is that estate taxes in most states, and definitely at the federal level, are not the primary issue. The primary issue is going to be what you want for your estate, what you want for your business. I'm going to talk about that topic that we have to talk about: love, marriage, and divorce, because divorce can really quickly end a family business. And I'm going to talk about some ways to prevent that. I'm going to briefly talk about life insurance and then we will conclude. On the next slide, I talk about um, some of the basic considerations and really some of the mistakes that people make when they're doing their wills. One mistake, and this is really not as big a mistake as it used to be because of the estate tax issue not being a big issue, but a lot of people will do what we call "I love you" wills, which basically leaves everything to their spouse. And if you have a pretty small estate, not a complicated estate, that might be okay. But if you have a family business or a pretty substantial estate, you might want to think about alternatives to the "I love you" will. Another thing that I've had a difficult time convincing clients not to do, and I understand it. People have this urge to leave everything to the children equally, to all their children equally. And that, it feels fair, but I urge people to think about the difference between equal and equitable. Have you had one child who stayed in the family business, has been working maybe for below market wages, doesn't really own anything because they've really been working for the family business? Your other child went off and became a doctor, or shudder the thought, a lawyer, or some other profession, and they're making good money and they've kind of made their own life. Is it fair for that one heir to share equally in the family business? And that gets to that next bullet: uh, heirs that are in the business versus heirs that are not in the business. And maybe you paid for the college education of one child, or maybe you provided money for them to purchase their own house, or something. Um, so I like to have people think about not so much, let's make sure each child gets everything equally, but what is going to achieve the goals of your estate planning? If your goal is to have the business continue on forever, then you might want to pick one child to take over the business. And we'll talk more about that. But leaving the business to the children equally often means that the business will have to be sold or that the children will fight and the lawyers will get all the money. So it's important to think about equal versus equitable. The other big issue that I've seen is the control issue. I've seen 90-year-old patriarchs who say they've started to give the bit control over the business to the children, but they really haven't. For example, you might have the patriarch who is in his 80s or 90s, or the matriarch, the owner of the business, and they say, well, I'm retired. I'm going to let you guys, the kids, run the business, and I'm going to, take a lot of vacations and just retire. But then he goes to the South Atlantic Jubilee or to the National Trade Show, and he comes back and says, I bought a new well rig. And what do you think the children are going to think about that? They hadn't planned for that expenditure. They thought you were out of the business, but here you are making major decisions. Very difficult for the family members to stop giving up control. So on the next slide, I show the four major tools that we're going to talk about today. Again, advanced medical directives, powers of attorney, wills, and trusts, in that order. So first, let's talk about advanced medical directives. And I talk about that on the next slide. And there's a history to this. If we go to the next slide, we can see that this really kind of started, we had living wills for decades, but some of you might be old enough to remember Karen Ann Quinlan. It was back in the 1970s, and there was a fight over, she was basically brain dead. There was a fight over whether the machine should be unplugged or not, that stretched on for quite a while. And if you can't remember Karen Ann Quinlan, you might remember Terry Shiva, which was in Florida, where her husband wanted to unplug the machines. The parents did not. There was a big battle between the husband and the parents about, whether she should be allowed to die or not. And again, she was brain dead, but the parents held out hope. Those two cases really generated a lot of interest in the United States for people to say, I want to control what's going to happen to me if I am in that condition. I do not want to have my family argue about it. I want to say in advance what the doctor should do. And so that is a very important thing these days. When I started practicing law, people would come into my office and say, I need a will. And I would have to say, well, how about a power of attorney? How about an advanced medical directive? In the past, probably 10 years, if not longer, people have started calling me and saying, I want a living will, because I saw my mom or my dad suffer, and nobody had the authority to make the decision, and I don't want my family to have to do that. And so it allows you to say that in advance. The next slide talks about some of the issues with advanced medical directives. Do you want the doctors to artificially prolong your life or not? And it's your decision. Most people say, do not artificially prolong my life. But I had a client one time who was 32 years old. He had been told several years earlier that he had cancer and he had 12 months to live. He is still alive, and that's been quite a while ago, more than 20 years ago. He came in and told me, I want an advanced medical directive and I don't want the doctors to ever unplug the machines. They were wrong once, they might be wrong again. But again, it's a very personal thing. And I tell people, I'm not going to tell you whether you have to have an advanced medical directive or not. It's your personal decision, and it is very personal. So that's one of the choices. Do you want your life to be prolonged or not? How about painkillers? Most people say, make me comfortable, give me pain medication, but don't artificially prolong my life. But the beauty of the advanced medical directive is you make the decision and you can tailor it to whatever you want. The next big decision, and this is a tough one, should you appoint somebody, your power of attorney, to make medical decisions for you? And as a lawyer, my answer is yes, please do. Because that way the doctor can look at one person and say, what do you want to do? In reality, a lot of people feel like some of their family members or all of their family members would not be able to do that. I find that if people have a nurse in their family, they immediately appoint the nurse as their power of attorney for medical decisions. However, the majority of my clients say I'm not comfortable with that. Although I would say that that's changing recently, and people are saying, I have to appoint somebody, and they do. But again, it's your decision, and you can decide whatever you want to do. When I do an advanced medical directive, I do at least 3 originals. And I wish I could say this was my idea, but it's not. My clients told me. They say that they take one of the originals whenever they travel and they carry it with them. Because if they're in Florida or out of state, that doctor's not going to know them. Although today some states have directories or online directories that doctors can consult. And West Virginia has a very good one, but other states do not. So take one with you. Now, I always tell my clients, next time you have a doctor's appointment, take your advanced medical directive with you. Talk to your doctor, give him or her the advanced medical directive. They'll put it in your file, they'll make notes, and they will know what your wishes are. And now this has changed a lot, but now hospitals and doctors encourage you to have an advanced medical directive. So again, I'm going to end the talk on advanced medical directives by saying, just think about it, make the decision that's right for you. The next thing I want to talk about on the next slide, though, I'm going to tell you, do it. You need a power of attorney. We all need a power of attorney. Anybody who is listening to this, who is 18 years of age or older, do a power of attorney if you haven't already done it. You need one because once you turn 18, your parents are no longer your guardian. And whether you know it or not, your spouse is not your guardian. So your spouse can't do things for you. A power of attorney appoints someone else to make decisions for you. And you are the principal. Whoever signs it is the principal. The person who is getting the authority to act is the agent. It has to be notarized. It is effective immediately. So the power of attorney does not have to wait until you are disabled. The power of attorney can act immediately. So it obviously has to be somebody that you trust. However, the attorney, in fact, has a fiduciary duty to the principal. That means the attorney, in fact, must act in the best interest of the principal. And if there are any issues, problems, you can go to court and have a court look at whether the agent is acting appropriately. This is important because if you don't have a power of attorney and you become mentally incompetent, you become mentally disabled, or perhaps even physically disabled, and you're just not able to take care of your affairs anymore. If you don't have a power of attorney, your family will have to hire an attorney and sue you to have a guardian appointed. Then the court will appoint a temporary guardian to the family member who is incompetent or alleged to be incompetent to make sure that all the hoops are jumped through. Then you have to have a court hearing. If nobody fights over who should be the power of attorney or the guardian, you're probably talking about $5,000. If your family members start fighting over who the guardian is, you're talking tens of thousands of dollars, hundreds of thousands of dollars. And I've seen that happen. A power of attorney will probably cost you $150. It is great insurance and you should do it. And even if you have a power of attorney, you can act on your own behalf as well. Next slide, please. When you're looking at your power of attorney, they can be durable or non-durable. In a lot of cases, unless the state has passed a law otherwise, the power of attorney ceases upon your disability. That doesn't make any sense. That's when you need a power of attorney. So check with your state law, and in any case, make sure that your power of attorney is durable, because that's when you're going to need it. Next slide. Powers of attorney can be general or specific. A general power of attorney gives the agent broad powers to do almost anything. And that's the most common. That's what most people are going to want. However, sometimes we do a special power of attorney. And that's going to be limited in either time or scope or both. And what I usually get here is somebody who's in the military. and they're going to be overseas for a year or 2 years, and they're going to buy a house or refinance a house. And so you appoint somebody as special power of attorney to sign those documents and to do what you need to do. But it's limited as to time, and it's limited as to scope. And so that's a special power of attorney. Next slide, please. Powers of attorney are very important with respect to real estate. They must be recorded prior to recording a deed or anything like that that's signed by the power of attorney. And don't do what I've seen people do. I've seen people show up at the closing with a power of attorney, and the closing agent is not going to be able to help you in that situation. They need to know in advance so that they can deal with that situation. Next slide. I hesitate to talk about this because I don't want people to get too paranoid or too complicated. But a lot of people are really concerned about, well, wait a minute, this power of attorney, they can go ahead and sign checks for me today. I don't like that. They might spend my money without me knowing about it. If you are really concerned about that, you can either put the power of attorney in an escrow with an attorney or an accountant or someone of that nature, and say that that attorney, whoever's holding the power of attorney in escrow, can only release that power of attorney when a certain event happens. And that event is usually the disability of the principal. So you're saying that power of attorney cannot be used until I'm disabled. A similar way to do it is to put in the power of attorney that this power of attorney is not effective until I become disabled. Now, the danger of this, either way, is what does disabled mean? How many doctors have to say you're disabled? Is it one doctor? Is it the best 2 out of 3? What does disabled mean? So that can be really tricky, but if you're concerned about what the agent might do while you're still competent, you can look at the alternative of having an escrow or what we call a springing power of attorney that does not become effective until you are disabled. Next slide, please. Should you have a power of attorney? I've already said this. Absolutely, yes. You got to avoid that court proceeding to have a guardian appointed. If you don't have a power of attorney, nobody else can make decisions for you. I often get questions about, well, my house is owned jointly with my spouse. All my bank accounts are held jointly. Do I still need a power of attorney? Absolutely, yes. Your spouse cannot sign for you on the house. And certain situations might come up like, do you need to be admitted into a nursing home or something of that type? You need a power of attorney. If you only take away one thing from today, go home. And if you do not already have a power of attorney, get one because you need it. At this point, I should have said earlier, If you have any questions, go ahead and type the question in the chat box. And the question will be relayed to me, and I will answer the question either as it's received or at the end of the webinar. But please feel free to type that question into the chat box whenever you have a question. With that, I'm going to move on to the next slide, which begins talking about wills. And wills are certainly important, but in my honest opinion, not as important as a power of attorney, or at least they're equally important. One point I want to make about the power of attorney. A lot of people say, well, I have a will, and I've appointed an executor. So if I become incompetent, my executor can make decisions for me. That is not true. Your will is a worthless piece of paper until you die. Your executor is not your executor until the will is introduced into the courthouse and put of record. So if you are still alive, the power of attorney is the effective document. The power of attorney and the will fit together like a hand in a glove. While you're alive, the power of attorney is effective. The second that you die, the power of attorney disappears and the will jumps to life and becomes the effective document. So both of the documents are important to have. With your will, you're going to appoint an executor. You're going to appoint guardian for your minor children if you have any. And you're going to have instructions as to who should get your property. Those are the main things that are going to happen in the will. You can also get some estate tax savings, but as I'm going to talk about, unless you have a really huge estate, you're not going to have an issue with estate taxes. So that is going to probably not going to be an issue for you. I did get a great question, so I'm going to pause for a second and go back to powers of attorney. The question was whether a healthcare power of attorney is sufficient. And that's a really good question, and I'm sorry that I missed that. I meant to say something about it. The reason that I talk about a healthcare power of attorney when I talk about advanced medical directives is that if you have a general power of attorney, and in that general power of attorney, you say that my agent has the authority to make medical decisions for me, if push comes to shove, the doctor or the court, if it gets that far, may not enforce that. In my opinion, the safest thing to do is have a general power of attorney that covers everything. And you can include healthcare in there if you want. But I think even if you include healthcare in your general power of attorney, you need to have a separate document that talks about what happens if you become, and now I always hate when I have to talk about this because I feel like the Grim Reaper or something, but the language of a healthcare power of attorney or an advanced medical directive says, if I'm in a vegetative or comatose state with no hope of survival, then here's what I want you to do. And I think you need to have a separate healthcare power of attorney or advanced medical directive to deal with the healthcare issues, and then a separate general power of attorney to deal with everything else. You can appoint the same person on both, or you can appoint different people, but I think you need to have two. So that's a great question, and I appreciate that question. And and while I'm on appointing people and I'm getting ready to talk about executors, I'll say that your power of attorney can be anybody. It doesn't matter if they live in the same state. Doesn't matter, if it's a family member, it can be a family member. It usually is a family member, but it does not have to be a family member. And you should, of course, appoint an alternate. And you should appoint an alternate for all of these things. Similarly, your advanced medical directive, your power of attorney, your medical care power of attorney, can be anybody. It can be a family member. It can be anybody in state, out of state. However, on the advanced medical directive or the healthcare power of attorney, you probably want somebody who's probably going to be there, so that if a quick decision needs to be made, they're there, you can make the decision. You should always appoint alternates. Might have another question here, not another question yet. You should always appoint an alternate or more than one alternate. I get paid to be paranoid. So if you appoint your spouse to be your your power of attorney, that's great. If you appoint somebody else that's about the same age as you as your alternate, I'm a little nervous. I'd rather have somebody named, whether it's your first alternate, second alternate, somebody who is younger than you and who is very likely to be around when you need them. The other thing that I worry about is if you appoint people who might be on the same vacation as you are, in the same plane, on the same cruise ship, in the same car. What if something catastrophic happens? And so I remember I had one friend who came to me, and people often come to me for a will when they're getting ready to go on a big trip. And they were going on a big trip. It was mom and dad and all the kids and all the grandkids and grandma and grandpa. And so when they started doing alternates, I'm like, I want an alternate somewhere here, whether it's your fourth or fifth alternate or something that's not going to be on that cruise ship. And yeah, it's paranoid, but it happens every once in a while. So if we go to the next slide, will formalities, and each state has something a little different, but for the most part, your will needs to be dated. It needs to be signed at the logical end by the person who is making the will. And depending on the state, you need 2 or 3 witnesses in the same room at the same time. And here is where the coronavirus has affected us attorneys. I'm paranoid again. It's hard to get a lot of people in the same room now because of the virus. And some states have passed laws that allow notaries to notarize by video and things like that. but we're nervous because wills are very formal documents. And so I did a will recently, a will signing, and we were all outside on a porch, and we all had a face mask on, and we were all more than 6 feet from the next person. And that might sound silly, but we were taking precautions. But for any of these, like, nobody can go to the bathroom. They all have to be in the same place at the same time. Nobody can leave. Very formal. And a lot of people, one question that you might have is, I can write my own will, right? Or I can go to Staples and buy one of those will forms and fill it in. And my answer to that is, if you like lawyers and you want to see lawyers make a lot of money, do your own will. Because there are so many little mistakes that you can make that there might be a challenge. One thing that lawyer drawn wills do that to me is worth the money, and I don't like lawyers. So I'm not saying this because I like lawyers. I'm saying this because I want to save you money and heartache. The lawyer will have what's called a self-proving affidavit in it. If you do your own will, when you die, somebody's going to take the will to the courthouse, and they're going to want the 2 or 3 witnesses to come to the courthouse too, and be under oath and say, I was in the same room at the same time with that testator, that person who made the will, and they were of sound mind and body, and I signed it. And I've had some old wills that didn't have this self-proving affidavit on it, and I had to go track down witnesses. And it was always in Wisconsin for some reason. But tracking down witnesses is expensive and time-consuming, and you don't want to do it. What this self-proving affidavit does is the witnesses are put under oath right there, and you do the affidavit right there. When you pass away, all they have to do is take the will to the courthouse. You're done. You don't have to track down the witnesses. So that's a really good feature. Let's go to the next slide, where, again, you can do your own will. And a holographic will is a will that is dated, signed at the logical end by the testator, and I'm a lawyer, so I like to use fancy words. Testator is the person writing the will, the person whose will it is. And it has to be entirely in the testator's handwriting. Holographic wills are money-making things for lawyers. I've seen the situation where you bought a form at Staples and you filled in the blanks on the form in your own handwriting, and then you signed it at the end. What's the problem with that? Everybody sees it, don't they? It's not entirely in your handwriting. Not a valid will. I've seen situations where somebody with a lot of money wrote their own will by hand, and the will was fine, but they left millions and millions of dollars to a charitable organization. They got the name wrong. 7 different charitable organizations filed lawsuits saying they meant me, they meant our group. And so the lawyers got a lot of money. The charitable organization didn't get much. It's worth it, in my opinion, to get a lawyer to do your will for you. It's going to cost a little bit of money, but it's kind of like an insurance policy. Another really good question, and, and one that I run into a lot: where do I put my will? And who should I give copies of my will to? Great question. Um, you should put your will in a safe place, whether that's your safe deposit box or if you have a lock box at your house. The important thing is to tell somebody where it is. I have many cases where somebody dies and nobody knows where their will is. They're like, I know mom had a will. She told me she did, but she didn't tell me where she put it. The number one place that I find them is in a drawer in the kitchen, which is not where you should put them. Put them in a safe place, let somebody know where they are. A lot of attorneys will actually keep your will in their safe deposit box for no additional charge. So that might be something that you look at. But tell somebody, in any case, tell somebody. If you put it in your safe deposit box, make sure that your executor or your power of attorney or somebody is on the signature card and is able to get into your safe deposit box. Since 9/11, banks have been very strict. If you're not on the signature card, you cannot get in and get the document. And again, you might be appointed executor in the will. You go to the bank, you say, I need to get into the safe deposit box to get the will. I'm the executor. The bank's going to say, show me your papers that you're executor. I can't. I have to get into the lockbox first to get the will. Well, you can't get in the lockbox because you're not executor. So make sure they're on the signature card. Another great question. Thank you. Next slide. The will has no legal effect until you die. You can change your will at any time, but it's best to have a new will written. Please do not, I've had this happen too. Please do not take your old will or your present will, mark things out, and then write in what you want to replace it with. That's a lawsuit waiting to happen. Don't take a copy of your will and do that unless you're clear that you're just doing that to take it to the attorney. Best thing to do is get a new will done. If you're incompetent, you can't change your will. But otherwise, you can change your will at any time. Next slide. Kind of related to the earlier question that I got. Next slide, please. Is that you should also tell your executor that you've appointed them executor. It's nice for them to know that in advance, and you might want to ask them if they're okay with that. What happens if I die without a will? Some people think if you die without a will, the state decides who gets the property. If you die without a will, the state doesn't get the property, but they do indeed decide who gets the property. It's usually going to be your surviving spouse and your children. It depends. Some states, everything will go to the surviving spouse unless you have children surviving you of someone other than the surviving spouse. So if you had a prior relationship, prior marriage, you had a child, then you got married to someone else. In most states, the surviving spouse and the children, all of your children, will share in your estate. In some states, if you have a surviving spouse and no children by anyone other than the surviving spouse, your surviving spouse will get everything. In some states, it will always be split up. So again, you need to look at your particular state and see who gets it if you die without a will. Most importantly, do a will, and then you don't have to worry about it. Next question that I get is, how about rights of surviving children and rights of surviving spouses? So I want you to think about it before I go to the next slide. Do children have any right to your property? Next slide, please. No. Children have no right to inherit from their parents. The only exception to that, the only valid challenges to the will would be if there was fraud or undue influence. For example, a young man or woman moved in with your parent when they were 80, 90 years old and persuaded them to leave everything to them, and it was all a scam. If you can prove that, which is very, very difficult, um, you can have the will overturned. Or if one of the children persuades the parents to leave everything to them instead of the other children, and it was in a situation where the child was exercising undue influence, you can have the will overturned. Very, very, very difficult to do. And lastly, if the parent was incompetent when they did the will. And so that last factor, that's hard to prove too, because you have to have a doctor saying on the day that the will was signed, that person was incompetent. If I do a will and there's any question, I will have a doctor's note that I will put in the file. Whenever I do a will, regardless, I will engage in chit chat with the person doing the will in the presence of the witnesses. And people think I'm just talking to. Well, I am. But I want to show that the person signing the will is competent. They know what they're doing. So it's really a dual purpose there. The next slide talks about how about surviving spouses. And they do have a right to part of your estate. And what I'm about to say is going to sound sexist, but it is what happened. What was happening 30, 40 years ago, husbands were getting girlfriends and gifting everything they owned to their girlfriend. And then the husband dies, and the surviving spouse gets 1/3 or 1/2 of the estate. 1/3 of zero is zero. Now, I have been reminded pointedly at some of the seminars that I've done that wives can also get boyfriends and do the same thing. And so it happens with everybody. So what the law says now is that if you give something away and the spouse doesn't sign off on that, the spouse is entitled to a certain percentage of the value of that item. And I've had a few of these cases too, where we've had to go track everything down, figure out the value, and come up with what the spouse is entitled to. I've also had people write their wills so that they leave the minimum amount that they have to their spouse. But in any case, spouses are entitled to part of your property. Now, the important thing with a family business, where you may not want the surviving spouse to be part of the family business if they're not part of that biological family that owns the business. If you are gifted something, or you inherit something like a family business, and you keep that separate from the joint property with your spouse is not entitled to any part of that. So very important to keep good records and to keep property that you want to be separate. And we'll talk more about that at the next webinar. Next slide. We're coming into the home stretch here, so I'm going to try to move on here. Trust. And trust, a lot of people are selling trust out there. They can be good things, but not for everybody. A trust is when somebody gives legal title to property to one party, which is called the trustee, and tells the trustee to hold on to that property for the benefit of somebody else, the beneficiary. And the person establishing the trust can give money or property to that trust. And they can do that trust when they're alive or after. They can put it in their will. Next slide. The trust can be revocable or irrevocable. If it's revocable, you can terminate it or change it at any time. If it's irrevocable, whatever you give the trust is gone. You do not own it anymore, the trustee owns it. In order to get it out of your estate for tax purposes, it has to be irrevocable. And a lot of people want to retain control, so they have a problem with that. Next slide tells the benefits of a trust. It avoids probate. If you live in California, Maryland, Florida, New York, several other states, that can be important. If you live in Virginia, West Virginia, South Carolina, North Carolina, not so important because probate is not expensive. A huge benefit is the trust is private. When you die, your will is recorded at the clerk's office. Anybody can look at it. The trust is never recorded at the clerk's office. It can be, doesn't have to be. You can keep it a secret. So if you're going to keep one of your kids out of your estate, you might want to do a trust. If you have somebody with special needs, people who can't manage their money, or minors, you can put it in a trust. It's very flexible. You can allow the spouse to receive income, but keep the property out of the estate for tax purposes. And you can have some management expertise if there are, special things that you need to manage. Next slide. The next slide talks about some of the reality. And I did get a question on one of these issues. The trust does not reduce your estate taxes unless it's irrevocable. And then it might be a taxable gift. So, and estate taxes aren't a big deal anymore. Avoiding probate in some states is not a big deal, so you need to look at that. It does not protect assets from creditors, again, unless it's irrevocable. And there are a lot of people out there selling trusts when they're not needed. Watch out. The other thing to watch out for is putting your property in a trust might increase your income tax liability. In some states, it's a big difference. So think about that issue as well. Now, what I'm seeing a lot of people say is that I don't trust my kids to have their money at 18 or 21. So I see a lot of trust in the will that says, I give this to my kids, but they get part of it when they're 30, part of it when they're 40. I had somebody who their kids didn't get everything till they were 70. The kids were 70. So it's very flexible, a very good tool to use in some circumstances. Next slide. I'm close. We started a little late, so I'm going to take the speaker's prerogative and go a couple minutes overtime here. And I keep saying that estate and gift tax is not as important as it used to be, and it's not. However, it is still important. The estate tax exclusion and gift tax exclusion in 2020 is $11.58 million. If you have up to that amount, you can give it away in your will or during your life, and you don't pay any federal estate tax. Notice I said federal. Watch out for your state. Your state might be different. And particularly, again, California, New York, Florida, Maryland, some of these states, it can be costly. You need to take a look at it. The gift tax exclusion in 2020 is $15,000. I'll talk about that in a second. There's a spousal exclusion, so I can gift as much as I want to my spouse and pay no tax. I can give as much as I want to charity and pay no tax. Next slide. I'm not going to talk about this much because we're kind of short on time and it's really complicated, but you do have to think about it, especially if you own real estate. Uncle Sam does you one favor and you have to die to get it. When you die, the basis of everything you own is stepped up to the fair market value. So I'm going to give a really simple example. You bought real estate years ago for $100,000. It's worth $1.1 million now. You sell it. You have a capital gains tax on the difference between 1.1 million and 100,000. You pay a capital gains tax on $1 million. If I gift that property to my child, their basis is $100,000. If they sell it, they pay capital gains tax on $1 million of gain. When I die, the basis of that property is $1.1 million. I know I'm going through this fast, but I gift it. My kids have to pay tax if they sell it. I give it to my kids in my will. Basis is stepped up to 1.1 million. Kids sell it for 1.1 million. They pay zero tax. That $1 million gain disappears and nobody ever has to pay tax on it. So think about when you gift, it's better to gift cash or other things that don't increase in value. $1 is $1. but real estate, stocks, things like that, they increase in value, we hope. So think about that when you're doing your gifting. You might still want to do the gift, but think about it. Next slide. So I said a $15,000 gift tax exemption. I can give $15,000 per year per donee to anybody I want, and nobody pays tax on it. If husband and wife, they can give $30,000 per year. So I can say, for example, but don't worry, I'm not. Everybody listening to this webinar, I'm giving you $15,000. I don't pay tax on it, you don't pay tax on it. And then on January 1, 2021, I can give it to you again, and nobody pays tax on it. So it can reduce your taxable estate. You can be more equitable with your heirs by giving lifetime gifts to some of that. You can gift back and forth between spouses. There's a lot of things you can do with that. So something to think about. Next slide. So think about any questions, additional questions that you might have. I'm going to look to see if we have any questions, and go ahead and submit those if you have them. In the meantime, the next slide gives you some information. This webinar was brought to you by Water Systems Council. There is the link to the membership application and contact information for Aaron Kaufman, who is our Member Services Director. Aaron would be happy to talk to you at any time about becoming a member. If you go to the next slide, we have some upcoming webinars. On August 27th, I'm going to do the 4th and final webinar in this series. And I had to go through this one pretty quick. So if you get us questions between now and August 27th, I would be happy to address those questions on August 27th. And I'm really excited to tell you that my good friend Alex White is going to be doing some financial planning webinars in September. So stay tuned for more on that. And I'm not sure if we have another slide or not. Yes, thank you. And thank you all very, very much. I'm going to make one more check here. I don't see any more questions. So I want to thank all of you for being here for the webinar today. And I'm always happy to answer follow-up questions. Contact Water Systems Council if you have any questions, or if you want any, maybe you thought of another webinar we can do. Let Water Systems Council know that. And you can even contact Water Systems Council if you have complaints about the webinar today. But thank you for taking the time. I've enjoyed talking with you, and I will hopefully see you all on August 27th. Thank you.